Banking Law and Practice RBI Act 1934. Reserve Bank of India was established under RBI Act 1934 on recommendations from John Hilton Young Commission 1926 called Royal Commission on Indian Currency and Finance. It is the Central Bank of India and was nationalized in the month of January 1949. Before RBI came into being, the Imperial Bank of India from SBI or State Bank of India was conducting the central bank's function. RBI is managed by a central board of directors and has one governor, provision for 4 deputy governors and 15 directors, and has 4 local boards at Mumbai, Delhi, Calcutta and Chennai. The functions of RBI includes issuance of currency, banker to government, which means transacts government business and manages public debt, banker's bank, which means keeps deposits of commercial banks and act as lender of last resort, provides export refinance and does liquidity adjustment facilities, acts as controller of banks, controller of credit, and ensures statutory reserves in the Indian banking system. Banking Regulations Act 1949. Banking Regulations Act 1949 came into being as Banking Companies Act 1949 and was changed to Banking Regulations Act 1949. This act is not applicable to non-agricultural primary credit societies, primary agricultural credit societies, and cooperative land mortgage banks. Some of the provisions of this act is that it reserves the power to Reserve Bank to issue bank directives to determine policy for advances and for every bank to maintain a certain portion of demand and time liabilities as statutory liquidity ratio. It also regulates and makes sure every bank publishes its balance sheet on the last working day of March every year on Form A and profit and loss account on Form B mentioned in the third schedule of this Act. Negotiable Instruments Act. Negotiable Instruments Act was passed in India in the year 1881, which came into effect in March 1882. Under the Negotiable Instruments Act, negotiable instruments means and include bill of exchange, checks payable to order or bearer, and promissory notes. However, according to the Indian Currency Act, Section 21, a currency note is not a negotiable instrument. Negotiable instruments can either be negotiated under Negotiable Instruments Act or can be assigned under Transfer of Property Act by following the given procedures. Since the activity of negotiation is easier than assignment, most parties dealing with a negotiable instrument accept the process of negotiation. Some of the terms one encounters in the case of negotiable instruments are holder, who is a payee or endorsee of a negotiable instrument or a check, and holder in due course is a person who is a payee or endorsee or bearer who must have the instrument in his possession. Banker-customer relationships. According to the Banking Regulations Act 1949, Section 5C, a banker is a person undertaking the business of banking by accepting deposits from public for the purpose of lending, which is repayable on demand or otherwise withdrawable by draft, check, or through a likely manner. According to the Reserve Bank of India's KYC or Know Your Customer policy, December 2004, a customer may be a person or an entity who maintains an account with the bank and has normal business relationship with the bank. A customer may also be a person on whose behalf the bank maintains an account, beneficial owner, and may be beneficiaries of transactions done by intermediaries such as stockbrokers, solicitors, as permitted under law. Bankers' obligations. Bankers' obligations or duties may be to honor checks of customers according to Negotiable Instruments Act and also to maintain secrecy of bank accounts of their customers. Bankers' rights or lien. Lien has been defined as the creditor's right to retain possession of goods and securities owned by the debtor until the debt has been fully paid. Lien also does not include right of sale of securities and goods and is available on goods and securities only including debentures, bonds, share certificates, promissory notes, bills and checks. A lien is not available for deposit as deposits are neither securities nor goods. There are three types of lien: general lien, particular lien, and banker's lien. In general lien, the creditor gets the right to retain possession of all amounts due from debtor until it is paid or discharged. This type of lien or general lien is available for attorneys of high courts, policy brokers, factors, and bankers. In particular lien, according to Section 170 of the Indian Contracts Act, the creditor gets the right to retain possession of goods and securities for which dues have arisen and not on other dues. In banker's lien, the right of lien can be exercised only if the possession of the property is obtained lawfully by a banker. However, a banker can sell the goods or securities after giving a reasonable notice to the debtor. Types of bank customers. Some of the bank customers may be a minor, a partnership firm, a limited liability company, a joint stock company, a Hindu undivided family, a trust or societies and clubs. If the customer is a minor, in which case a guardian is appointed by the court or where a court of ward is appointed as guardian until the minor attains 18 years of age. If the customer is a partnership firm, the law is according to Indian Partnership Act of 1932. There should be a partnership deed, and for banking firms, the maximum number of partners allowed is kept at 10. Accounts can be opened for a partnership by obtaining a copy of partnership deed or a partnership declaration form if no deed is present, which indicates formation of partnership, account opening form, operating powers for the account, and undertaking and specimen signatures. If the customer is a joint stock company, the Companies Act 1956 recognizes the JSC or joint stock company to be a legal person. The company is supposed to maintain a bank account, and outgoing proceeds and incoming proceeds are moved through this account. No introduction is whatsoever required to open an account for a joint stock company, as the certificate of incorporation, memorandum of association, and articles of association are public documents. If the customer is a HUF or Hindu undivided family, the business is ancestral and its ownership, common possessions, and enjoyment forms the basis of Hindu undivided family. As per Hindu common law, the Hindus, Sikhs, and Jains are the communities who can form a HUF, also called coparcenary. It consists of one common living ancestor and his male descendant up to 3 generations next to him. According to the Supreme Court, a HUF is a creature of law and it cannot be created by parties or act of parties unless a stranger may be affiliated to the Hindu undivided family by adoption. Hindu undivided family is different from partnership and it is not governed by the Indian Partnership Act. Senior-most co-partner is called Karta or manager, and a HUF declaration form or account opening form and loan documents should be executed by the Karta in his own capacity and by all other adult co-partners in their personal capacity to make them personally liable. When the documents are executed by Karta alone and not by co-partners, the Hindu undivided family assets become liable. Karta is personally liable and co-partners' share in HUF is liable, but co-partners are not personally liable.